You go to bed a law-abiding citizen. You wake up, a felon, no crime. No arrest. Just one line in the Federal Register, and suddenly, the gun you legally bought, built, or carried yesterday is illegal today. It's not a law passed by Congress, it's not a court-ordered, it's a quiet rule change, buried in the fine print, that redefines your rights while you're asleep. Because right now, thousands of gun owners across America are waking up to letters, raids, and charges, all because of one sentence they never even saw. If you carry, if you build, or if you own, this episode could be the difference between freedom and a felony. So before you find yourself on the wrong side of a new rule, hit subscribe, because what you're about to learn isn't just law, it's survival. No congressional vote. No Senate debate. No public notice. Just a single agency, changing the definition of freedom. They called it a clarification, a minor adjustment. But buried in those 300 pages of bureaucratic language was a trap. A trap so precise that millions of gun owners wouldn't even know they triggered it. The ATF had quietly redrawn the legal line between ownership and offense, turning paperwork into potential prison time. For years, that line was cleared, and a pistol brace was just that. A brace that a homemade frame was just a project. But then, with the stroke of a pen, they became felonies. No one warned them, no news alert. No headline. Just silence. Until the letters started arriving. Overnight, law-abiding Americans, veterans, collectors, builders, became targets of a law they never saw coming. But here's the part almost no one talks about: the court saw it coming. For over a decade, 3 Supreme Court rulings had built a wall around the Second Amendment, warning every government agency not to cross it. But instead of backing off, one agency decided to test how far they could go before the wall cracked. In 2024, they pushed too far. A lawsuit was filed. A judge pushed back. And suddenly, the entire balance of power between citizens and the federal government was on trial. Because this wasn't just about one gun, or one rule, it was about something much darker. Who really writes the law, Congress, or the agencies that claim to interpret it? Somewhere between the Constitution and the Federal Register, something snapped. A single judge read the rule, and whispered one word that Washington didn't want to hear: unconstitutional. The agency could have backed off. Instead, they doubled down, setting off a chain reaction that's now climbing its way through the courts like a slow-moving earthquake. Because what's coming next isn't a press conference, it's not a new law, it's a reckoning, written in ink, and stamped by the Supreme Court itself. And the next move? For years, agencies wrote the rules, and the courts simply nodded. Until one case, one seemingly ordinary lawsuit, reached the marble steps of the Supreme Court. Beat. And for the first time in decades, the justices didn't just listen. They pushed back. Inside, the air was electric. No shouting. No cameras. Just the quiet weight of history, about to shift. At issue, a single question, one that could unravel nearly half a century of unchecked federal power. Does an unelected agency have the right to define a crime without Congress ever passing a law? The government argued it was interpretation. The court saw it for what it was: control. And then, with one decision, the justices swung harder than anyone expected. They didn't just question agency power, they dismantled it. Because once the court struck back, every agency that touched the Second Amendment felt the shockwave. Rules that once carried the force of law suddenly meant nothing. The courts had flipped the script, and the fight for freedom had entered a new phase. But if you think the agencies surrendered, think again. Because behind the scenes, they're already planning their counterstrike. The court had spoken. The people had won. And for the first time in decades, the agencies that shaped America's gun laws were forced to step back. But victories in Washington never last long. Because while the headlines faded, a different kind of meeting was already taking place. They called it regulatory continuity. A harmless phrase, on paper. But inside that room, it meant something else entirely. When the court struck down their authority, the agencies didn't quit, they adapted. Because if they couldn't make the rules directly, they'd find new ways to enforce them indirectly. The loopholes started small: advisory letters, guidance documents, and quiet reinterpretations of existing law. Then came the partnerships, local law enforcement, digital monitoring, and licensing pressure. The court had given freedom back to the people. But the agencies were already writing a new playbook, one that wouldn't need Congress or even approval. They called it operational discretion. A bureaucratic ghost, invisible to the Constitution, and untouchable by the courts for now. And here's the part no one saw coming. Those same reinterpretations are being tested right now, in real time. Each one could decide whether the court strike holds, or whether the government's counterstrike succeeds. Because freedom doesn't end with a ruling, it ends when no one's watching the next one. The court struck back. The agencies countered. And now, the future of your rights rests in the balance of one final decision. This is where everything meets again: the agencies, the Constitution, and the question no one wants to answer. Can a government lose control and still keep power? One ruling could cement the freedom millions fought for, or erase it in a single paragraph. Because if the court reverses course, every agency in America will have its power back, and every gun owner will feel the recoil. It's not just about parts or paperwork anymore, it's about precedent, the kind that outlives generations. Behind these walls, the final appeal begins. And when the decision drops, the landscape of the Second Amendment will change forever. It started with 3 rulings that armed America. Now, one decision could disarm it, not by force, but by interpretation. And the most dangerous part? You won't see it coming until it's already law. When the court struck back, most Americans thought the fight was over. But for the agencies, it was only half-time. They didn't need new laws. They just needed new methods. Because while the Constitution limits what they can write on paper, it doesn't stop what they can build in code. The silent war isn't fought with bullets or ballots. It's fought with databases, definitions, and digital compliance. Every trace, every form, every background check, it's all information. And information is the new battlefield. When Congress said no new gun registry, they didn't build one, they built 20 smaller ones, spread across agencies, stitched together by shared data. That's how modern control works. Not by seizing your rights in daylight, but by tracking them in the dark. They call it modernization. But every new form, every digital update, every redefinition, tightens the noose around the Second Amendment. And while Americans debate headlines, the real war moves one click at a time. Because the silent war doesn't need your consent, it only needs your compliance. Somewhere right now, another memo is being drafted. Another rule is being reinterpreted. Another right is being quietly prepared for review. And when it's finally revealed, you won't read about it in the news, you'll feel it, in the laws that suddenly apply to you. Every great power shift begins with a document, and 1791, it was parchment, and 2025, it's policy code. They call it modernization, but behind the language of efficiency lies something else entirely, a blueprint for quiet control. Hidden in the footnotes of recent directives are new definitions, words like transfer interface, risk identification, and tracepoint analysis. Bureaucratic terms that sound harmless, until you realize what they really mean. It means your purchases, serials, and even maintenance records can be linked, cross-referenced, and flagged, not by a judge, not by Congress, but by an algorithm. This is how control evolves, not through confiscation, but calculation. Every new form improvement, every digital upgrade, every policy clarification, they all plug into the same expanding network. And now, with AI integration, the system doesn't just track actions, it starts predicting them. They call it prevention. But what it really is pre-criminal suspicion. The founders built a nation on individual judgment, but the new system runs on predictive control. The new enforcement doesn't knock on your door, IT appears in your inbox, IT adjusts your background check, IT redefines your eligibility, before you ever know it. And that's the brilliance, and the danger, of the hidden blueprint. T doesn't change the Constitution, T just rewrites the world around it. So the question isn't who writes the laws anymore. It's who writes the code that enforces them. If you carry, if you own, if you still believe freedom should be defined by the people, not by agencies, hit subscribe now. Because this isn't politics anymore, it's preparation.